Hello friends, welcome to our channel Khatriya Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation. Ready? Start. We are of the view that this issue is no more valid after the clarification given by the firm Stop. These appeals are filed under Section 10 of the Companies Act, 1956 within the permissible period of limitation. Stop. On the date of filing these appeals, Section 434 of the Companies Act, 2013 was not notified. Stop. In exercise of the power conferred under Section 419 of the Companies Act, 2013, the central government constituted National Company Law Tribunal and National Company Law Appellate Tribunal. Stop. On the same day, notification issued for transfer of pending matters or proceedings or cases before Company Law Board to National Company Law Tribunal. Stop. Section 434 came into effect from that date. Stop. As far as the appeals against the order of Company Law Board are concerned, any person aggrieved by any decision or order of the Company Law Board made before such date may file an appeal to the High Court within 60 days from the date of communication of the decision or order of the Company Law Board to him on any question of law arising out of such order. Stop. Learned Counsel made a comparison of the operative portion of the CLB order ought to be executed and the order passed in execution petition. Stop. He submitted that the declaration, relief granted, and vesting of the property are behind and beyond the decree. Stop. Without following the procedures laid under Civil Procedure Code, the NCLT had passed the impugned order. Stop. NCLT had clearly stated that the properties of VR associates are to be kept as security and only in the event of remote need the properties of VR associates are to be conveyed to Omega Solutions and 7.80 acres to Jane Brother and Company. Stop. Thus, it is very clear through the above observation of the tribunal that the property is to be held only as security and cannot to be conveyed unless there is remote need. Stop. While doing so, the NCLT erred in vesting the land to the owner of the property without any material or justification of remote need. Stop. The property is worth several times the principal amount decreed and interest thereon. Stop. The property held as security is greater in value than the money due. Stop. Therefore, this property cannot be conveyed. Stop. In the instant case, the Company Law Board gravely erred in not considering amount due and the value of the property conveyed, which is held only as security. Stop. Further, the learned counsel appearing for the respondent, that is, Omega Solutions, submitted that after the order passed by the tribunal, the order of the Company Law Board got clarified through the order of the tribunal. Stop. At no point of time in the past the appellants had sought for extension of time to honor their commitment of repaying the invested money with interest. Stop. Due to their failure to pay the money within the time prescribed and no sign of attempt to pay the money had resulted in the remote need to invoke the second limb of the Company Law Board order, that is, the transfer of the land. Stop. The declaration of title and vesting of the property is the natural consequence to the decree and not beyond or behind the decree. Stop. The order of the NCLT constituted under Section 10 of the Companies Act is to be enforced by NCLT itself. Stop. Only in case of inability To execute the order, NCLT needs to send the case to the court. Stop. Therefore, these appeals lack question of law and they are abuse of law to prevent the original owner from enjoying the fruits of the decree. Stop. In exercise of its powers and the discharge of its functions, company law board has to be guided by principles of natural justice and shall act in its discretion. Stop. It also has power to regulate its own procedure. Stop. Section 634 empowers company law board to execute its own order. Stop. It enables company law board to send execution petition to a court in case of its inability to execute such order. Stop. It is left to the discretion of company law board that whether it has the ability to execute or not. Stop. So, application of civil procedure code in general or order in particular case under Companies Act, 1956 can be executed by the National Company Law Tribunal. Stop. NCLT executes its order. Stop. The guiding principle to be followed is the principle of natural justice. Stop. The appellant's case is not that executing the order has violated of principle of natural justice. Stop. The appellant's submissions proceed on a fundamentally erroneous basis that the scope of this tribunal's jurisdiction under Section 10 is not limited to adjudication of questions of law arising out of the order but also extends to questions of facts in certain circumstances. Stop. This is a misreading of the judgments of the Supreme Court. Stop. On 14/9/2021, patient visited AIMS hospital again. Stop. As per the document on the record of the case, she visited the AIMS hospital on 14/9/2021 with the history of hit over the abdomen by aforesaid date. Her husband at late night on the aforesaid date. Stop. She also came with the history of pain in the abdomen and bleeding. Stop. On examination, she found to have her BP as 160/110. Stop. It is also mentioned in the oral examination of the patient that on the aforesaid date the patient was in distress and she was having serious injury in the abdomen. Stop. On examination of abdomen, uterus was of 34 weeks and heart sound was not localized. Stop. She was also having bleeding in vagina. Stop. Her ultrasound was also conducted on the aforesaid date and on ultrasound examination, it was found that the heart activity of fetus was absent. Stop. As per the opinion of the medical officer of AIMS hospital, the cause of the separation could have been either because of the hit over the abdomen or due to high BP. Stop. On the basis of the aforesaid documents, I cannot say that whether the patient was a case of habitual abortion or not, because in pregnancy a patient can develop high BP sometimes and there is no record of the previous BP of the patient. Stop. सो ये हमारी हाई स्पीड डिक्टेशन थी, ठीक है। अब इसके जो फ्रेज वगैरह होंगे वो हम नेक्स्ट क्लास में देखेंगे, ठीक है। इन अ सेशन हम इसके अंदर जो भी फ्रेज है, जो भी शॉर्ट आउटलाइन है वो देखेंगे और उनकी प्रैक्टिस करेंगे ताकि इजीली हम इस मैटर को हाई स्पीड पर लिख सकें, ठीक है। ये दो मैटर से मिक्सअप है, एनसीएलटी का मैटर है और जो सेकंड है वो एम्स की डिक्टेशन है, ठीक है। एम्स की ज़्यादा हार्ड नहीं है, लीगल डिक्टेशन है, ठीक है। सो बी प्रैक्टिस फॉर द बेटर फ्यूचर।